All right, messages from the House. Messages from the House.
From the House of Representatives.
Mike who?
From the House of Representatives, March 26, 2021. Message number 310, conferees appointed for Joint Conference Committee number 1. Mr. President, the House appointed House conferees to meet with the Light Committee number 1 from the Senate on amendments to House Bill 49. House conferees are Representative Simpson, Chairman, Representative Hunt, Representative Provenza. Message number 311. Mr. President, House appointed House conferees to meet with the Light Committee number 1 from the Senate on amendments to House Bill 7. The House conferees are Representative Greer, Chairman, Representative Bear, and Representative Jennings. Message number 312. Mr. President, the House appointed House conferees to meet with the Light Committee number 1 from the Senate on amendments to House Bill 73. House conferees are Representative Zwanitzer, Chairman, Representative Crago, and Representative Wilson. Message number 313, corrected, conferees appointed. Mr. President, the House appointed House conferees to meet with the Light Committee number 1 from the Senate on amendments to House Bill 121. House conferees are Representative Nicholas, Chairman, Representative Larson, and Representative Walters. Signed, Wendy Harding, House Chief Clerk. From the House of Representatives, March 29, 2021. Mr. President, the following bills passed the House on third reading. Message number 314, Senate File 39, Digital Identity, ayes 48, noes 11, excused 1. Message number 315, Senate File 40, Wyoming Money Transmitters Act Amendments, ayes 58, noes 1, excused 1. Message number 321, Senate File number 62, repealing sunset date for the Office of Consumer Advocate, ayes 56, noes 4. Message number 322, Senate File number 72, Financial Counsel and Reporting Budget Reductions, ayes 59, noes 1. Message number 323, Senate File number 79, Medicaid Billing for School-Based Services, ayes 55, noes 5. Message number 324, Senate File 93, Witchy Repayment Program Veterinary Medicine Students, ayes 60. Message number 325, Senate File number 119, Investment of State Permanent Funds, ayes 56, noes 4. Signed, Wendy Harding, House Chief Clerk. Mr. President, the following messages refer concurrence requests. Message number 316, March 29, 2021. The Senate File 44, Solid Waste Cease and Transfer Program funding passed the House on third reading in an amended form. Ayes 59, excused 1. House respectfully asks the Senate to concur by adopting amendments. Message number 317, Senate File 47 passed on third reading in an amended form. Senate File 47 is Clinical Laboratory Regulation. Ayes 59, excused 1. House respectfully asks the Senate to concur by adopting amendments. Message number 318, Senate File 50, COVID-19 Business Relief Programs Agriculture, passed on third reading in an amended form. Ayes 57, noes 2, excused 1. Message number 320, concurrence requested. Senate File 52, Insurance, Mental Health, and Substance Use Parity, passed the House on third reading in an amended form. Ayes 55, noes 4, excused 1. Message number 319, concurrence requested. Senate File 58, Wyoming Investment in Nursing Funding, passed on third reading in an amended form. Ayes 42, noes 18, excused none. House respectfully asks the Senate to concur. Message number 326, concurrence requested. Senate File 25, Animal Impound Proceedings, Bond and Disposition, passed on third reading in an amended form. Ayes 40, noes 19, excused 1. The House respectfully asks Senate to concur by adopting amendments. Signed, Wendy Harding, House Chief Clerk.
Reports from standing committees.
March 29, 2021. Mr. President, your committee number 2, appropriations, to whom was referred House Bill 127 engrossed, public health amendments, respectfully report same back to the Senate with the recommendation that it do pass. Ayes, Senators Hicks, Kinski, and Steinmetz. No, Senator Guru. Excused, Senator Perkins. Senator Kinski, acting chairman. March 29, 2021, Mr. President, Committee number 2, appropriations, to whom was referred House Bill 244 engrossed, State Investment Administration. Respectfully reports same back to the Senate with a recommendation that it do pass. Ayes, Senators Guru, Hicks, Kinski, and Perkins. Excused, Senator Steinmetz. Senator Kinski, acting chairman. March 29, 2021, Mr. President, Committee number 2, appropriations, to whom was referred House Bill 195 engrossed, Wyoming Medical Review Panel repeal. Respectfully reports same back to the Senate with a recommendation that it do pass. Ayes, Senators Guru, Hicks, Kinski, Perkins, and Steinmetz. Senator Perkins, chairman.
We're at that order of business, consideration of bills on general file. Nope, Senator Wasserberger.
Thank you, Mr. Vice President. I have House Bill 188, and I ask that it be re-referred to Senate Appropriations for them to review.
House Bill 88 has been re-referred.
House Bill 188.
188 has been re-referred to appropriations. Bar any objections, so ordered. Senator Perkins. We're at that order of business, consideration of bills on general file.
Mr. Vice President, I move that we resolve ourselves into committee of the whole.
Committee of the Whole, Senator French, would you like to lead us in that effort?
We better vote on the motion, Mr. Vice President.
All those in favor say no. I mean, aye.
Aye.
Those opposed, same sign. Motion passes. Senator French.
Senator French, or Mr. Chairman, for first order of business, would you turn off my microphone, please? Thank you.
I will in a second. Can you just tap it? Okay. The Committee of the Whole will please come to order. The first bill for our consideration is House Bill 229. The reading clerk will read the bill.
House Bill number 229 engrossed, the Livestock Identification Choice Act, sponsored by Representative Neiman, an act relating to agriculture, was referred to committee number 5, which returned to committee recommendation that it do pass amended. Ayes, Senators Boner, Bouchard, French, Cost, and Wasserberger. Senator Cost, co-chairman.
You've heard the reading of the bill. What's your pleasure? Senator Wasserberger.
Thank you, Mr. Chairman. I move that when the Committee of the Whole rises to report, do so with a favorable recommendation that House Bill 229 do pass. There is a standing committee amendment, and I ask that it would be read in at this time.
House Bill 229, Standing Committee Amendment number 1 to engrossed copy, page 3, line 15, delete.
Senator Wasserberger.
Thank you, Mr. Chairman. I would move standing committee amendment number 1 to House Bill 229 and ask for your favorable vote. Ladies and gentlemen of the Senate, this amendment simply on page 3, line 15, where it has this section, we delete this section and we insert animal disease traceability. And essentially for the purposes of animal disease traceability, Wyoming livestock owners may choose to use various different types of identification. And then on page 3, lines 19, where it says federal government is, we strike and then we insert Wyoming Livestock Board. So it reads, any additional methods that are later approved by the Wyoming Livestock Board as official identification. And essentially, it puts it in control of the Wyoming Livestock Board on how we identify our livestock in our state. And I would ask for your favorable votes.
Questions? Senator Wasserberger? Are you ready for the question on standing? Okay, those in favor, say aye. Aye. Opposed? Okay, we're back on Senator Wasserberger.
Thank you, Mr. Chairman, and I would turn the bill over to the outstanding senator from Goshen County.
Just a minute. Senator Steinmetz?
Thank you, Mr. Chairman, and I have been accused for a time or two from being outstanding in my field, literally. Usually shoveling an irrigation ditch or two. All right, so good senators, today we bring you House Bill 229, the Livestock Identification Choice Act. The purpose of this bill is to codify in Wyoming law the various legal animal identification devices that are available to Wyoming producers under current federal law. Prior to 2013, livestock industry and the federal government worked together to develop a program to conduct essential animal disease tracing in the event of an outbreak. In 2019, without following proper legislative process, the federal government issued a mandate to phase out the use of metal ear tags beginning in January 2023. A lawsuit was filed against this unlawful mandate, and the federal government quickly withdrew. However, in July of 2020, it happened again. House Bill 229 will ensure that Wyoming livestock producers are not deprived of their ability to decide which official animal identification device best meets their needs. The options include the following official identification devices: metal ear tags, radio frequency identification devices or RFID ear tags, brands, tattoos, group and lot identification, and back tags. House Bill 229 will help ensure that any change to existing official identification will go through the proper legislative process to amend existing law. Until such a time, House Bill 229 will serve as legal authorization to Wyoming livestock producers to continue to exercise the choices authorized under current federal law. And so if you go to your bill, that's what we're seeking to do. You see in page 2, we're just taking out national because we're making this more state-centric. And on page 3, the balance of the change in section C, and the good senator, the vice chairman of Ag, already told you what the amendment did, so I'm just going to read you that section. For the purposes of animal disease traceability, Wyoming livestock owners may choose to identify animals using any method set forth in 9 CFR Part 86 as adopted on January 19th, 2013, as well as any additional methods that are later approved by the Wyoming Livestock Board as official identification. On page 4, nothing in this section shall be considered or construed to limit or amend the brucellosis surveillance and testing program administered by the state. And that's very important. Then the balance of the bill just takes out the word national. And so that's this a good little bill. And I'd stand for any questions, or if there are none, call for the question.
No questions on the bill? All right. All those in favor of Senator Wasserberger's motion that when the committee of the whole rises to report that it do so with a favorable recommendation of House Bill 229, say aye. Opposed, no. I think the noes have it, maybe. Yeah, that's a joke. Yes, sir. Okay, House Bill 229 has passed the committee of the whole. All right. Next up is House Bill 207. Reading clerk will read the bill, please.
House Bill 207 engrossed, coal-fired generation facility closures litigation funding, sponsored by Representative Harrelson, an act relating to the administration of government. Was referred to committee number 9, which turned to committee recommendation that it do pass amended. Ayes Senators Anderson, Whitman, and Cooper. No Senator Rothfuss. Excused Senator Wasserberger. Senator Anderson, Chairman. Was re-referred to committee number 2, which returned to committee recommendation that it do pass amended. Ayes Senators Hicks, Kinsky, Perkins, and Steinmetz. No Senator Guru. Senator Perkins, Chairman.
Okay, you've heard the reading of the bill. What's your pleasure? Chairman Perkins?
Thank you, Mr. Chairman. I move that when the committee of the whole rise to report, that it do so with a due pass recommendation on House Bill 207, coal-fired generation facility closures, litigation funding. And for an explanation of this bill, call upon Senator Biteman. If you would, please call upon Senator Biteman, Mr. Chairman. And there. And the first standing committee amendment is one from the Minerals Committee, and so we'll turn it over to the Minerals Committee to deal with Standing Committee Amendment 1.
Sit down.
Senator Biteman?
Thank you, Mr. Chairman. I'll go ahead and handle the standing committee amendment number 1. If I could have that read in, please.
House Bill 207, Standing Committee Amendment number 1 to engrossed copy, page 5, line 9, delete.
Thank you. I move standing committee amendment number 1, House Bill 207, and ask for your aye vote. I'll dispense of the standing committee amendment because it's pretty basic. As you see on page 5, line 9, we're going in and striking beginning on and entering on or before October 1st, 2021. And yeah, it's simple as that. I'll ask for your aye vote.
All right, you've heard standing committee amendment number 1. What's your pleasure? Those in favor say aye.
Aye.
Opposed? Hearing none. The motion to adopt standing committee amendment number 1, committee of the whole to House Bill 207 has passed. We're back on the bill.
Thank you, Mr. Chairman. We also have another standing committee amendment from the Appropriations Committee. I'd like to have that read in at this time too, please.
House Bill 207, Standing Committee Amendment number 2 to engrossed copy, page 4, line 9, delete.
Thank you, Mr. Chairman. And I'll defer to the good chairman of Appropriations.
Chairman Perkins.
Thank you. I believe that it has been read in and moved if I did catch that. Has it been moved? Okay, I'll go ahead and move Standing Committee Amendment number 2 to House Bill 207 and ask the body's favorable consideration. So what this did is that as this bill came, as the engrossed version came from the other side, they had deleted the original appropriation from 1.2 million to 500,000. This this amendment puts it back to 1.2 million. And so that's what this amendment does. Just Mr. Chairman, for the advice of the members of the committee, the good senator from Goshen County and I went down and talked to the governor's office just to find out how much money is left in these accounts and where we're at. And so what we found out was there is 99,000 approximately left in these accounts. The budget that we just voted on a little while ago with a joint concurrence, I believe put 1.2 million or 1,250,000 in added to this account. So now you're up to, basically 1,350,000. Then with this one, it puts, this amendment would put another 1.2 million in. That's the effect of this amendment. And what we do know is these things are expensive. And if we want to, it's not just to hire lawyers. Most of this stuff goes into, sometimes it goes to hire lawyers, but a lot of times it's used to develop the economic data and the other expert and other information necessary to defend or prosecute a case. And if this money's not expended at this behalf, it will continue in this fund unless we do something else with it. So anyway, that's the amendment and the reasoning behind it, and some of the facts that we have, and would stand for questions and ask for your aye vote. Thank you, Mr. Chairman.
Questions? Senator Ellis.
Thank you, Mr. Chairman. Just a little bit more information about how the Appropriations Committee will look at how these funds are spent. I'm just kind of wondering how granular of a level the legislature will have to look at some of those fees, not just hourly rates of attorneys, but those economic studies. I just want to make sure that we're being very mindful of how we're spending these dollars. So I'm just curious to know from the Appropriations Committee if we'll see that level of review. Thank you, Mr. Chairman.
Senator Rothfuss.
Thank you, Mr. Chairman. A follow-up question as well along the same lines. One of the concerns I had in committee with this legislation is that we really already have a fund that does this, and we do this all the time. In fact, it was an hour before, I think, when the governor filed a lawsuit along these lines compared to when we were in committee. So I'm curious, as we're looking at this amendment, contemplating adding another 500 or 700,000 in addition to this bill. Do we project that we would be able to spend the existing $1.25 million within the next year, and that we would need to add another 700,000 on top of the other 500,000 between now and then? Or is this something where we can pace ourselves a bit? Because it really seems to me that we've already got a handle on this. So I'm curious what the discussion was on the Appropriations Committee about why we might increase it further.
Senator Steinmetz.
Thank you, Mr. Chairman. So you'll see in section 3 on page, whatever page that is on, 5, that beginning October 1, 2021, and each 6 months after, until October 2030, the governor and the attorney general shall report to the Joint Appropriations Committee on this account and what's going on with it. So that is a good thing. And then I would also point out, and I think the good explainer of the bill will go through the bill, but the reason that we put that extra money in there is on page 5 as well, because this is not just for the litigation for the coal-fired power generation facilities, but it's also for the actions that might impede the export of Wyoming coal. So we just felt that this was a fund that we could replenish, that the funds will revert back if they are not used, and we are requiring reports to do that. So we will be watching this money. We will be looking at how the funds are spent, and we will be keeping an eye on that. So I ask for your aye vote on the amendment.
Senator Perkins.
Mr. Chairman, if there's nobody else, I'll take my second time. If there is someone else, I'll sit down and wait for another question. Oh, it is committee of the whole. Thank you. Thank you. So, Mr. Chairman, for my second time, which I guess I can have a third or a fourth if necessary as well. So anyway, but who's counting? So as we talked about this, really originally the Coalport litigation fund was really at about $2.5 million originally. That's been expended over the last several years. There's been a few of those cases that have happened, and there's been quite a bit of money expended. In some respects, it was thought that if we had less in there, that there would be the opportunity for other states, particularly our sister state to the north, with respect to some of the coal export litigation, would participate. And so there was some thought, if the amount was initially reduced, that would give some impetus or encouragement to a sister state to enjoy or engage in that litigation as well and share the costs. But this bill itself doesn't anticipate that you'll have that type of litigation, because what this bill anticipates is that, and the classic example is as we took evidence in our testimony in our hearing, was that what you have is you have some tri-state electrical cooperatives that generally are supposed to be regulated by FERC, the Federal Energy Regulatory Commission. However, what you have is some states are now trying to impose and regulate on these tri-state with respect to renewable portfolio standards or other types of production or electricity production standards that may or may not be appropriate for that state to regulate, and therefore I impose its regulation upon an interstate cooperative. In those instances, it's unlikely that we would have, or we may have another state. It's just going to be state on state. And so there's not likely someone to share the costs of these types of litigation. If we're going to do these things, and we're going to have the state and the Attorney General do that, we need to make sure that they've got adequate funding to go ahead and do that. With respect to the expenditures themselves, I believe that any of these expenditures can be looked at. Some of the reports, until they're disclosed, some of the exports, until they're disclosed in the cases, may be subject to the attorney-client privilege, or at least the attorney work product privilege. But at some point, they will be available and be able to be demonstrated to the public. Although the expenditures themselves, who got it and how much, I think that those things probably will be a matter of public record. But they're, like I say, because it's involved in litigation, in some instances, the actual information may not be available until it is disclosed in any given case.
Senator Guru.
Thank you, Mr. Chairman. On and against the amendment. I guess we've learned today, we put $1.25 million into an account to litigate with a state to the west about shipping our coal, which I agree with, because I think that's a states' rights issue. And now we've learned that fund's been spent down to $99,000, and we need to put in another $1.2 million for this new litigation. Don't know how the old litigation's going. Hopefully we're winning, but never know, I guess, because we haven't heard. And this particular case, I'm not so sure it's a wise expenditure of our money right now. We seem to be in a mode where we're looking at all our expenses and cutting, but here we seem to just take carte blanche and put caution to the wind. We also just refunded, after cutting, we refunded 2 extra positions in the Attorney General's office. And I still have yet to find, I know that there's some expert stuff needed and some information needed and tables run and whatever, but probably a task force and then something else, but I just don't see it. When we're cutting across the board, why now we just seem to roll out the welcome mat and throw out money and without much explanation. So on and against, Mr. Chairman. Thanks.
Senator Nethercott.
Thank you, Mr. Chairman. On the amendment question concerning the source of the request of funds, I mean, has the executive branch requested the funds or the attorney general said, hey, we'd like to go sue this state? I mean, is that the source of this idea? Is that a way to generate revenue, or is this just us tying up funds for an opportunity that will likely not present itself in a meaningful way? Just tell me about the source of the funds and the source of the request. Is there any potential litigation that is even contemplated or discussion about that? How much money it would be needed? I mean, I get the desire. I just don't think it makes a whole lot of sense.
Senator Hicks.
Yeah, Mr. Chairman, just a little bit of information and background. When this was approached, because there was litigation in North Dakota against Montana, based on that state establishing a renewable portfolio that would preclude the rural utility companies from providing coal-fired electrical generation. So that went to the Eighth Circuit Court of Appeals. It was litigated for about 7 years. The disposition on that was the court ruled in the state of North Dakota and awarded the state of North Dakota $1.3 million that the state of Minnesota then had to pay for that. So how does that tie into the appropriation? We know that particular litigation ended up in the disposition of a $1.3 million payout to the state. But why is it important to the state of Wyoming to work for our coal-fired generation? Because number one, we generate revenue off those severance taxes that pay for our local jobs and economy. Number two, it creates a significant amount of jobs at our power plants. So it's about our severance taxes, it's about funding our schools, it's about providing those local jobs. The fact that we've had similar litigation to what we're contemplating right now with another state with a favorable disposition by the Eighth Circuit Court is something that we should explore, given to the neighbors to the south, and some of our other neighbors have done exactly the same thing with adoption of their state renewable portfolios, Mr. Chairman. So the question becomes is, well, what did the governor's office know, or the attorney general's? I'll leave that to my colleague to discuss, but when we presented this information, it was stuff that they had not considered in the past. And so there was a receptive nature that we may want to take a look at this. But it doesn't do any good to take a look at it if there's no money to proceed with an action if the executive branch so desired, Mr. Chairman. It's about selling coal, it's about creating jobs in Wyoming, and standing up through the court system for our economy on and for the appropriations, Mr. Chairman.
Senator Wasserberger.
Well, thank you, Mr. Chairman. On and in favor of the amendment and in favor of the bill. Members of the Senate, many years ago, I used to teach social studies at our local high school. It was a community of one high school at that time. And one of the things that was a very important precedent that I taught students about was a case called McCulloch versus Maryland. And in that case, a United States Chief Justice said, or wrote in the opinion, the power to tax is the power to destroy. And what was going on was Maryland was against the United States Bank at that time, and they wanted to tax the bank and get money from it. And United States Supreme Court said, no, you can't do that. And essentially what we're talking about here is no state can regulate another state's products. Those products can and should be free to move about the country in any way that they want. But that's not what's happening to the state of Wyoming's product right now. And as a result of that, we should support this amendment so that we can insist upon through the courts legally that the mineral industry of Wyoming's products can move about the country freely. And that's the reason for the amendment. That's the reason for the bill. I ask you to vote aye on the amendment. I ask you to vote aye on the bill.
Any other? Okay. Aaron, you ready for that? All those in favor of Senator Perkins' motion to adopt Standing Committee Amendment number 2 to House Bill 207, please say aye. Opposed? Believe the ayes have it. What's it? Okay. Since there's a call for division, those in favor stand, please. Division being called. I believe there's one more, maybe. Senator McEwen, possibly. Okay, thank you. Those opposed, please stand. All right. You may be seated. Those in the affirmative were 20, those opposed were 7. Okay, so amendment, standing committee amendment number 2 passes. We're back on the bill. Senator Beitman.
Hey, thank you, Mr. Chairman. Now that we've got the standing committee amendments disposed of and the proper funding put back into this bill, let's go through the bill real quick. It's broken out into a couple different sections. Section 1, is your basic legislative findings, important in this case because it really sets out the case before us and the legislative intent behind what we're trying to accomplish as a legislature here, putting this money into this fund. We all know how important coal is to our economy. You go over to page 3, Romanet 7, the commencement prosecution of lawsuits to challenge state laws restricting the import of Wyoming coal into their states. The use of coal in the production of electricity is necessary to minimize and eliminate harm. And that gets to the direct question of who's been harmed here. Obviously, Wyoming's been harmed. That's why we need to fight this in court on the Commerce Clause issues. It's important that we have that money in there, and we got that money. That's section 2 is the appropriation. Section 3 talks about the reporting and the status of make sure that the Wyoming legislature is kept up to date on the progress from the Attorney General's office. This is a very important policy decision for us to make today. I hope that the Wyoming legislature will show that the state of Wyoming is serious about protecting our coal and our exports and protecting interstate commerce. And with that, I'll ask for your aye vote. Thank you.
Senator Nethercott.
Thank you, Mr. Chairman. For the love of coal, I love this bill and the efforts to fight for coal. As this body may recall, I've historically voted for those efforts to support funding for litigation concerning the port. So I just want that known. I do understand the source of the funds for Wyoming come from coal. So I get that too. Appreciate the recitation. But I do have concerns about the legislature determining what litigation the Attorney General's office and the governor should pursue, and starting to earmark dollars for certain types of litigation only because these are complicated issues. When I look at that $1.3 million award, it was after 7.5 years of litigation. I think the return on investment is likely lacking. Just my guess, what was expended by the state to get that $1.3 million award. Certainly looks like a big win for that elected official up there of recovering that money for the state and fighting. But whether or not it was a return for the taxpayers, I highly doubt it after 7.5 years of litigation. And those are some of the considerations that have to take place, which is a cost benefit for the taxpayers' money, which is whether or not this litigation should be pursued, say, over the defense or actions against other types of rights that might have a greater return on investment for the people of Wyoming. I'm not saying this isn't an avenue for the Attorney General's office to pursue. It certainly may be. But starting to earmark these dollars and we determining which litigation is more appropriate than others is a dangerous course. And I can certainly see next year, each of us bringing a bill, allotting X amount of dollars for the AG to prioritize certain types of litigation for certain types of actions that are important to all of us. That's not our job. That's not the delegation of those pieces. And so I just want to urge caution as we move down this path, because how could we not vote for this and not support coal? That's the equation. That's the fallacy of the argument being presented, that by voting against this bill means you're voting against coal. And nobody in this body is doing that. No one thinks that's correct. And no one doesn't support the efforts associated with this litigation. But that will be the argument every time we start earmarking or appropriating money for the AG to pursue specific causes. It's a very dangerous path. And I think it's also a second fallacy to assert that the AG's office cannot pursue this litigation without this appropriation. That's a false narrative. That's not an accurate connection. They certainly can pursue this litigation without this appropriation. With that, I just urge great caution to this body about the precedent that we're setting. I have a whole lots of ideas for litigation, and I can start legislating them that way. Litigating in the legislature. So I just urge great caution about what is actually being presented here and what isn't.
Senator Anderson, then Senator Ellis.
Mr. Chairman, on and for this bill, I want us to throw caution to the wind. We've got to get after this. We are way behind on getting this litigation done. Two companies went out to the coast and took over a facility that had huge issues they had to address, and they did that with millions of dollars. They addressed those issues thinking that they would be able to export coal from that facility. They were blocked by numerous entities in that state, and they still have that investment. They still have that port, if you will. And now we're being blocked by certain entities within those states. We need this litigation to get our coal moving to the Asian front. So on and for this bill. Thank you.
Senator Ellis.
Thank you, Mr. Chairman. Just some more questions about how these funds will be used. I think we discussed the idea that the Attorney General's office could be hiring outside counsel. And so I just want to have some kind of assurance that process will be really open and transparent about which firm might be selected. Because at the end of the day, my concern is about cost. I think that, if we're looking at certain attorneys across our country with this kind of expertise, it isn't cheap to hire someone. I mean, I'm guessing $500 an hour up to $1,000 an hour or more. And so I just want to make sure that we are being apprised of every cent that's being spent on this litigation, because we don't want to spend good money and at the end of the day realize that maybe we weren't filing lawsuits that we'd have a chance of winning. So I don't want to spend this money just for the sake of spending it, so that we feel good. I want to make sure that, if we're diving into this area, we have some discussion about our likelihood of winning. And so along those lines, I just want to also kind of throw an idea out there that we talk about the litigation that happened on the ports. Those were initiated by private companies. And I always thought it was a really responsible role for Wyoming to support that litigation, recognizing that those private companies invested a lot of money in their projects, hired their own attorneys, and we were taking a supportive role. My concern is, what if the state of Wyoming, with good intentions, starts initiating its own lawsuits that start interfering with those private suits? And I just wish we could be a little bit more thoughtful in how we tackle that. That was certainly a concern I had with the coal port litigation when we discussed this issue a few years ago. But I would like to just know that we're going to have an open bid for the selection of counsel. And then I want to make sure that how those dollars are being spent is completely transparent for the legislature and the public. Thank you, Mr. Chairman.
Senator Nethercott.
Thank you, Mr. Chairman. Real briefly, members, just of note here, just doing some quick, interesting search. So, you know, the one state sued the other in 2001, and do you know what happened a couple years later? That defendant state decided to sue that other state on a whole separate other issue. So what's happening here is these elected officials are playing games with the people's money, right? In these other states, posturing for positions. You sue us, we're going to sue you on another issue. So Minnesota then went ahead and sued North Dakota for hunting rights violations. They were discriminatory actions against their state for access to the other state's hunting rights and laws. That's what I see happening here, is a decade of litigation between these two states and posturing together. Just be careful not to get wrapped up in the pandering of lawyers who are taking the public's money to engage in public media campaigns, which I think is candidly what's happened here for that 1.3 is after 7.5 years of litigation.
Senator Perkins.
Thank you, Mr. Chairman. I just wanted to add a little bit of clarification that this isn't the legislature who's deciding who to sue and where to sue. I mean, what this is in the reading from the supplemental budget request for 21-22, which is the budget we just completed. The governor made a request. The governor's, I'll read verbatim. The explanation of the request is supplemental request. The governor's office is requesting $2.5 million for litigation and outreach coordination with the state of Montana related to the Supreme Court litigation of Wyoming, Montana versus Washington. The state of Washington denied a permit under the Clean Water Act, which would prevent Wyoming from shipping coal through a terminal in Washington. And the request is necessary for legal and related costs to prepare and present the case to the Supreme Court or a special master appointed by the Supreme Court. That's what the purpose is. It's not the legislature deciding whom to sue. It's still the executive branch deciding who and when to sue. What this bill as it is now will basically complete that supplemental request in full or awfully close to it. And so that's what it does. It provides that funding for the executive branch to do that. This is in the governor's office. It's not in the attorney general's office. So ultimately it has to be released by the governor. It's not just available for the attorney general to spend as she would deem appropriate, but it'd be in coordination with the governor's office. You can make your own decision about the appropriateness of that or the inappropriateness of that. As far as how that works, I think that most of what this is the governor and the attorney general's office looks to find the attorneys that they feel are best suited to present that case. The ones with experience, the ones with others. I know having talked with the executive a couple times in the past litigation, not advising them, but just getting a little bit of a status update from the executive on what was transpired in that. They were listening to and following advice of counsel in these matters. So, you know, it'd be nice if this is one of those things where it'd be nice if it was all competitive, but I think the folks that are in the legal business know that it's not just a matter of who can provide the best or the lowest cost service. If you're going to go win these cases, you have to just to go win them. But ultimately, you can decide whether that's appropriate or not. But I just wanted us to make sure that this is not the legislature telling the governor's office what to do. This is the governor's office asking for the funding to do what the governor's office wanted to do. Thank you, Mr. Chairman.
Senator Hicks.
Yeah, Mr. Chairman, just want to speak to the issue of us funding the legislature for litigations. Well, let me just walk through a little history. Legislature appropriated money over the North Platte River to sue the state of Nebraska. Colorado intervened and had a special master assigned by the Supreme Court. Guess who appropriated the money, Mr. Chairman? The legislature. When we litigated the state of Montana on the Yellowstone Compact, the legislature appropriated the money to litigate another state. In my time, we've appropriated money to litigate the federal government over gun confiscation. We've appropriated money to do coal export. We're appropriating money to do additional work if the Attorney General so deemed. So this is what we do in the legislature. We appropriate the money for those actions that we deem are appropriate for the state to take. That's our job. It doesn't say that we shall sue another state over this issue, because that would be a separation of powers issue that we don't have. But we can certainly set the priorities through the appropriations process, what's important to the legislature in the state of Wyoming, by appropriating money and earmarking it and say it can be used for this purpose, Mr. Chairman. That's what we do. We appropriate money for our priorities in the legislature. Now, if the executive branch disagrees with that, we have this process called a veto, and he can veto that, Mr. Chairman. But this is what we're supposed to do. We're supposed to set the priorities for the state of Wyoming through the appropriation process on and for the bill.
Senator Scott.
Mr. Chairman, I want to go back to some fundamentals here and see if I'm understanding the arguments correctly. Mr. Chairman, it seems to me that some private citizens, private firms are trying to engage in foreign commerce, taking coal from the state of Wyoming and selling it overseas. My understanding is that's perfectly lawful in terms of federal law, because the feds have the right to regulate in this area and have not forbidden this kind of activity. And that what's happened is basically the state of Washington is regulating foreign commerce to injure citizens of the state of Wyoming. And that seems to me what the fundamentals here are, and that the Constitution provides that the right to do that regulation is a federal and not a state issue. And then what I'm hearing is we haven't succeeded in legal efforts to allow our citizens, to allow our coal to be exported. And it's hurting our economy. And the argument I'm starting to hear against appropriating more money is that the legal system has just become totally ineffective. And we're losing our ability to engage in foreign commerce consistent with the federal law, which I thought was one of the things we were guaranteed under the US Constitution. I thought that was part of the whole purpose of the US Constitution. What is wrong with our legal system? Because that's the argument I'm hearing. Maybe I'm misunderstanding the argument that our legal system just doesn't work anymore.
President Dockstader.
Mr. Chairman, I'm going to trust our legal system. We'll sort this out. Who would have thought that we'd be at this point just a few years ago? Got a phone call from my county commissioners a few years ago, and they said, we got to talk. We're going to lose some power facilities in our county that will be a couple of 300 jobs. Then right behind that will be the loss of a valuable coal mine, maybe another 200 or 300 jobs. And in just the space of a few years, here we are facing the loss of jobs, facing the loss of communities as we know them, spin-off effects into businesses, less students in the schools. It goes on and on and on. Unfortunately, we're at that point. Litigation has to be a part of the discussion. And I know it could result in something where they come back and say, well, if you do this, we'll do that. But if we stand idle and we don't try to protect these jobs in some form or fashion, we've missed the opportunity to help Wyoming in ways that will affect it for another generation. We've had past leaders travel overseas, negotiate with foreign governments and say, we have the product. The government's saying, get the product to us. And then we're hindered in doing business and getting that product to them on and for the bill.
Senator Cole.
Thank you, Mr. Chairman. I come from Southwest Wyoming, and we have a rather massive power plant where I'm at. And we have a lot of my constituents work there, and it benefits the entire state. I think we're forced into this position to fight this litigation, because if we don't, no one else will. So I would stand in support of this for the sake of the folks that work in the state every day, doing an important job that, like Texas found out, they need reliable power production. And this is what this is about. And the rest of the United States may not realize this, but we're not going to get there just with wind and solar and such other alternatives because of the reliability issue. So I think we have to fight the fight. We have to spend the money to fight this fight. I can tell you the people in my district demand it. Thank you, Mr. Chairman.
Question being called. All those in favor of Senator Perkins' motion that when the committee of the whole rises to report, that it do so with favorable recommendation of House Bill 207. Those in favor say aye. Aye. Those opposed, no. House Bill 207 has passed committee of the whole. Next bill for your consideration is House Bill 43. Will you please read the bill? Yeah.
House Bill 43, Digital Assets Amendment, sponsored by the Blockchain Committee, an act relating to digital assets, was referred to committee number 1, which turned to committee recommendation that it do pass. Ayes, Senators Cooper, French, Cole, Costa, and Nethercott. Senator Nethercott, Chairman.
You've heard the reading of the bill. What's your pleasure? Chairman Nethercott.
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report it, do so with the due pass recommendation of House Bill 43, Digital Assets Amendments. Good senators, this is the work from the Select Committee on Blockchain, Financial Technology, and Digital Innovation Technology. This bill is amendments as indicated, and it provides further refinements to how our digital assets laws in Wyoming, which are profound, pioneering, and unique, work in our state. These amendments are really intended to provide further refinements and definitions associated with what a digital asset is and how it works within our Uniform Commercial Code. This is the law, and the origins of the original digital assets law is what's been adopted in about 14 other states based on our work. So really great work in front of us, committee members. Primarily providing a more narrowly tailored definition of a digital asset, as we can find on page 2, lines 11 through 13, really kind of narrowing that down. On page 3, recognizing that this chapter, that this particular section is considered a consumer protection statute, recognizing that the consumer protection statute trumps these other statutory sections. And so even though it's a digital asset, it is this new concept that everyone else is adopting our great work. Consumer protection laws still apply. Again, good senators, this is a bill in its effort for perfection so that we have the best and sharpest laws on the books for this, and so provides further details as to how to perfect a digital asset as a security interest. But with the definition of control. Provides more consistent language going into page 4 with the UCC, which is really important. On the bottom of page 4, so on lines 19 through 22, provides additional details associated with the financial statement and further information about how to manage a debtor that's located in Wyoming. On page 5, we're going into cleaning up some ambiguity and providing a lien cleansing provision. Further clarity and amendments to the bill really based on the great work through the blockchain task force and our experts associated with this, and a really great bill. Stand for questions, ask for your favorable consideration.
Senator Scott.
Mr. Chairman, on page 3, lines 15 to 18, where right now perfection of security interest of virtual currency or digital securities may be achieved through possession or control as applicable to the asset consistent with WS so-and-so. And we're saying that now, perfection of a security interest in virtual currency may be achieved, and perfection of a security interest in digital securities may be achieved by control. What does that mean?
Senator Rothfuss.
Thank you, Mr. Chairman. So this is a subtlety, first of all, that I'll say. UCC terms of art with regard to possession and control and perfection are deep, complicated, and nuanced in ways that there's probably 5 people seemingly in the country that fully and completely understand. So there's my first caution. Fortunately, I think 4 of those 5 people have scrutinized our digital asset laws in Wyoming and have given us criticism time and again about how we should change those nuances. So the concept here is that we were previously providing for the fact that digital securities and virtual currencies would both achieve perfection through possession or control, depending on the asset type, and that was defined previously. This is clarifying that the virtual currency may achieve that perfection through possession, and the perfection of a security interest in digital securities may be achieved by control. So the difference there with possession in the way that our digital asset property rights are structured, you can contemplate it as a bearer bond. That's the expression, or that's the concept that we used a lot in committee. With a bearer bond, if you're holding the bond and you're the bearer, you possess it. That was a unique thing that Wyoming did with regard to our digital asset custodianship, first of its kind, and it was very pioneering, was that concept. Digital securities are not possessed that same way, because you don't possess them, and I shouldn't have used the word possession. See, it's tricky to delineate these. They're not perfected in the same way necessarily, because if I have control of it, but somebody else effectively has possession, now think of a stock certificate concept, which is a security. I don't necessarily have that stock certificate with me. It's not the equivalent of the bearer bond. As a security, it's typically possessed from that bearer concept by some other entity, but I'll have control of it, which means that I can determine its transactions, I can sell it, I can buy it, I have the control over it, so I can perfect the ownership of it accordingly. This is clarifying that difference, and I hope that provides some context. And again, it's UCC code, it's very complicated, but that's the difference.
Senator Nethercott.
Thank you, Mr. Chairman. So if you look at the paragraph in one, this new language on 17 through 18, the language in red that you automatically go to, is actually not changing anything in substance. It's just a rewording of the provision to make it clearer. So nothing in substance is really changing. But when you read the statutory section in total, this is related to the perfection of a security interest as it relates to, and we're treating digital assets as we would general intangibles. And so if you have possession or control over them, that is a way to achieve perfection. And that's all that's going on here, treating it like a general intangible.
Any other questions? We're going to call for the question. All those in favor of Senator Nethercott's motion that when the committee of the whole rises to report, that it do so with a favorable recommendation of House Bill 43, say aye. Those opposed, no. House Bill 43 has passed the Committee of the Whole. The next bill for our consideration is House Bill 17. Will the clerk please read the bill?
House Bill 17 engrossed range management at military training areas sponsored by the Transportation Committee, an act relating to the military department, was referred to committee number 8, which returned to committee recommendation that it do pass amended. Ayes, Senators Anderson, Furphy, Landon, McEwen, and Pappas. Senator Landon, chairman. Was re-referred to committee number 2, which returned to committee recommendation that it do pass. Ayes, Senators Guru, Hicks, Kinsky, Perkins, and Steinmetz. Senator Perkins, chairman.
You've heard the reading of the bill. What's your pleasure? Chairman Landon.
Thank you, Mr. Chairman. I would move that when the Committee of the Whole rises to report it, do so with a do pass recommendation on House Bill 17. There is a standing committee amendment. I would ask that that be read in at this time.
House Bill 17, Standing Committee Amendment number 1 to engrossed copy, page 1, line 6, after.
I would move that standing committee amendment, Mr. Chairman, and let's just dispense with it right now. It's a technical correction, and I think that you'll be able to track that pretty easily, fellow senators. So unless there's a question, I would call for question on the standing committee amendment.
All those in favor of Senator Landon's motion to adopt the standing committee amendment number 1 to House Bill 43, please say aye.
Okay.
Opposed?
Point of order.
I'm sorry, House Bill 17. I apologize.
One more time, if we could do that standing committee vote, Mr. Chairman, that'd be great. Thank you.
All those in favor of Senator Landon's motion to adopt standing committee amendment number 1 to House Bill 17, please say aye.
Aye.
Opposed, say no. Okay. That has passed. Back on the bill.
Thank you, Mr. Chairman. For an explanation of this good little bill, I would ask that you call on the general, the senator from Laramie County.
Thank you, Mr. Chairman.
Senator Pappas.
Thank you, Mr. Chairman. This bill comes to you from your Transportation Interim Committee. It was an interim topic that we took up. It's a bill that creates a range management and grazing operations at our military training areas, and it creates a fund for depositing the monies from grazing fees. Just a little bit of history. There are grazing operations going on now at our military facility just north of us up here at Camp Guernsey. And the issue with the grazing operations at this time is that the federal government, the Secretary of Defense, has come out and said that there will be no funding from July 2021 and on for any types of range management operations like grazing. In the past, it's been done on the federal government's nickel, and we've been providing range management with federal funds to date. That no longer can happen. And it's important for us to continue managing the ranges up there. For number 1, it's a fire risk mitigation. As you well know, we did have a major fire up there years past. We certainly don't want to see that again. By grazing on these ranges, that keeps our wildfire danger down. There's 9 leases ongoing, and the military department is at a little bit risk because they've continued on since July, maintaining these leases. They're with two different entities, and it's a great partnership. Let me tell you that there's 61,000 acres up there that need management. It includes rotating the livestock to move out of the way when they have maneuvers and other operations. moving them from place to place to keep the grass down, repair fences, all of that takes time and effort. The grazing fees do return money to the state. Last biennium, we saw $376,000 returned to the general fund. So this bill basically creates a state program to continue the grazing operations at Camp Guernsey. Without this, those grazing operations will cease. So let's look at the bill. If you go to page 2, really, that's where it starts. Paragraph A, there's created a military department range management and grazing program. You'll see that this is only on military training areas owned in fee by the military department and are not on state land. So we're not talking about state lands. This is just military department land. They oversee day-to-day range management operations and grazing operations. They'll arrange for personnel and materials for range improvements, including maintenance. They'll determine the animal unit grazing usage and develop and monitor forage plans. These plans are actually already in place. They'll maintain leasing and neighbor relations. So if you go on to page 3, you also see in paragraph B that the military department range management and grazing account is created. The account, as I said, is anticipated on bringing in last biennium $376,000. So what we're doing in this paragraph, we're allowing the account to not exceed $200,000 per biennium. We'll continuously appropriate the $200,000 to military department. And then if you see at the bottom of the page, anything excess of $200,000 will be deposited into the general fund. On to page 4, the military department will have to promulgate rules to administer the section. There will be a report required annually to the Joint Transportation, Highways, and Military Affairs Committee. And then in sections 3, you'll see there's an appropriation. It was much higher when it came, when it started, and then the other body amended it down, and we did have testimony from the military department that yes, they can get by with the $50,000. This is just basically seed money so that they can get the program started. That's a one-time expenditure, and after that, and also none of the appropriation can be used for anything other than this. And so I think it's a win-win. The program is needed to continue the grazing operations at Camp Guernsey and possibly other military lands. But it also does bring money to our general fund. So I ask you for your favorable consideration.
Senator Scott.
Mr. Chairman, question. How many animal units are involved on an annual basis in this grazing?
Senator Pappas.
Mr. Chairman, I actually don't know that. I know they gave us a range of $29 to $32 per animal unit, but I don't know how many. So they're returning $375,000 per biennium. I don't know whether you can do the math or not. I'm not sure, but I can find out for you. I'll find out and bring that back in subsequent readings. Thank you.
Any other questions? Call for the question. All those in favor of Senator Landon's motion that when the committee of the whole rises to report, that it do so with a favorable recommendation of House Bill 17. Those in favor say aye. Aye. Those opposed, no. House Bill 17 has passed committee of the whole. The next bill for our consideration is House Bill 41. Would you please read that in?
House Bill 41 engrossed interstate crowdfunding exemption amendment sponsored by the Blockchain Committee, an act relating to interstate crowdfunding, was referred to committee number 1, which returned to committee recommendation that it do pass. Ayes Senators Cooper, French, Kolb, Costa, and Nethercott. Senator Nethercott, Chairman.
You've heard the reading of the bill. What is your pleasure? Chairman Nethercott.
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report it, do so with the due pass recommendation of House Bill 41, intra-state crowdfunding exemption amendments. To explain this amazing little bill, I'll call on Senator Rothfuss.
Senator Rothfuss.
Thank you, Mr. Chairman. Mr. Chairman, interstate crowdfunding exemption amendments comes from the Select Committee on Blockchain, and it was some work we did. This is a program that already exists, and this actually doesn't change the program very much, but changes 4 provisions in it that help to make it more attractive to those individuals that are interested in utilizing this tool. Intrastate crowdfunding, the concept there is that all of your funding, and you can contemplate this as seed investment for a startup or something along those lines, or develop business that needs to raise some capital. If all of the money comes from investors in the state of Wyoming, then you can get a bit of an exemption from certain provisions of securities law, which would require a great deal of additional bureaucracy and oversight. That's the concept, but the reality is the provisions we put in place when we passed it in the first place didn't end up being particularly attractive because some of the numbers were a bit too low, and our reporting requirement was actually more onerous than the SEC's reporting requirement. So this changes 4 things to help reflect requests from business and industry. The first of those is on page 2. There are 2 tiers to this. One is for unaudited entities that are trying to put this together and that have not had a full financial audit as approved by the Secretary of State's office. The next tier will be for those that have had a full audit. The previous level you can see on lines 12 and 13, the previous level was a $2 million maximum threshold. This changes it to a $3 million maximum threshold for the funds that you can raise under this program without having an audit. On to page 3. The original draft of this intrastate investment system had $4 million as the maximum. It's been kicked up to $10 million as the maximum, assuming that the issuer has made available to each prospective purchaser audited financial statements that have been reviewed. This conforms more closely to other states and is basically consistent with best practices. This is the level that our Secretary of State's office is comfortable supporting. The third change, which is really the significant, probably the most significant change, is on the bottom of page 3. Under the original provision, no individual investor through this program could invest more than $10,000. This increases that to $25,000. And for every one of the individuals that's engaged in the program, there's effectively bureaucracy, paperwork, and challenges that go into it. So there was a strong request by those that are interested in this investment strategy of increasing it from $10,000 to $25,000 for a single transaction. And then the final change, Mr. Chairman, is on page 4. In the B section, and then the rest of the bill is simply conforming language. There were required quarterly reports when you used this program. Apparently, nobody asks for quarterly reports. It was more onerous than the feds, so the language is changed such that the information shall be available upon request and always available to those investors at any point throughout the operation of the program. That's the bill, Mr. Chairman. I'd be happy to answer any questions. Otherwise, I'd call for the question.
Any questions? Hearing none. Call for the question. All those in favor of Senator Nethercott's motion that when the committee of the whole rises to report, that it do so with a favorable recommendation of House Bill 41. Those in favor say aye. Those opposed say no. House Bill 41 has passed committee of the whole. The next bill is House Joint Resolution number 9. Will you please read that in?
House Joint Resolution number 9 engrossed, local government investment in equities, sponsored by Representative Sweeney. A joint resolution proposing to amend the Wyoming Constitution to allow local government entities to invest in stocks and equities upon a 2/3 vote of both houses of the legislature. Was referred to committee number 1, which returned a committee recommendation that it do pass. Ayes, Senators Cooper, French, Kolb, Cost, and Nethercott. Senator Nethercott, chairman.
You've heard the reading of the bill. What's your pleasure? Chairman Nethercott.
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report it, do so with the due pass recommendation of House Joint Resolution number 9. To explain this joint resolution, I'd call on Senator Perkins.
Senator Perkins.
Thank you, Mr. Chairman. What you have here is a ballot, is basically a joint resolution to amend the Wyoming Constitution. The purpose of this is that under the current Constitution, there is no provision or no anticipation like there is in other areas in which the political subdivisions of the state, such as our cities and counties, can invest in equities. And it's been, there are some cities and communities in our state, some counties in our state that over time have developed some fairly significant reserves, and they would like the opportunity to have those invested, very similar to how the state invests its money. And so what this does is it's certainly not mandatory, but it provides the opportunity that you could have something similar to what we've talked a little bit before about a pool A. It would be a different pool in which local governments, or in some cases, I guess it could even be special districts, but a city or a town, if they had reserves that they wanted to invest, could turn that over to the state treasurer, and it would be invested along with the other investments of the state in accordance with the whatever pool and whatever recommendations were set up with respect to that. Like Mr. Chairman, what we found out is years ago, there's been a fund in which local governments could invest, but it's been restricted because of the Constitution only in fixed income. So bonds and things of that nature. What we found over the last 10 years that oftentimes bonds return not very much return, and indeed have turned out in many cases to be oftentimes as risky, particularly in low interest rates and low interest rate environments, because the volatility of bonds just doesn't provide, it provides a risky investment, and also with some limited opportunities for rates of return. And so, like I say, what would happen is you would come back, if this were to pass, the legislature would come back and do something very similar to what we did earlier. You would have a risk rated portfolio, which there could be would not exceed that. The legislature would set that risk standard, and then the State Loan and Investment Board would work out in conjunction, most likely with the Investment Funds Committee, what are the appropriate investments to receive that and to realize the return associated with the amount of risk involved. And then the state treasurer would execute that on behalf of these entities. Cities, towns have been asking for this for quite some time, but without a change in the Constitution, it just isn't available to them. There's no requirement that they participate if this were to pass. It would be up to the local governments to decide how much of their reserves they would invest this way, and they would realize they would take those risks, but also realize the rewards would come from those additional investments. I think that there is, I think I'm working on an amendment tomorrow to go with the ballot language that you see, which is at section 2. I think that ballot language isn't very clear, and I think we can do a little bit better than that. And so I'll have an amendment, a second read amendment on that. But ultimately, what you see is the bill is on the bottom of page 2, the top of page 3, which simply the legislature may provide for law for the investment of county, city, township, town, school, district, any other political subdivisions in the capital stock and association in capital stock of any association or corporation, and may designate those funds that may be invested. That mirrors very closely to what the state does with its funds. And without this, it's not, they don't have that opportunity. With this, they would have that opportunity. And with that, Mr. Chairman, I'll stand for questions on that anybody has about this.
Senator Hicks.
Yeah, Mr. Chairman, real quick, why would we restrict this just to equities and stock and capital and companies, given that there's a whole range of investment mechanisms and other entities that we currently do at the state level? I mean, I know you mentioned bonds, but bonds, and then there's real estate, and there's a whole bunch of others that, if I understand the way the bill is, this would be invested through the state of Wyoming. And again, I do think that needs clarified in that constitutional amendment language, that it's not the entities actually doing the investment. It's investment through the state treasurer's office in those accounts. But I'm just wondering why we would limit it only to stocks of corporations and equities, the way I currently read it.
Further questions? Senator Perkins.
Mr. Chairman, this language mirrors what the state can invest in, and it's limited to capital stock. Ultimately, it's been a very expansive interpretation that's happened. So if real estate, usually that comes in the form of a REIT or other type of investment. There's some kind of entity or fund in which does that. So ultimately, those investments oftentimes appear to be in the form that they're a capital stock, or they're a stock of that corporation. There's a broad range of investments that the state has vested in. And so I say that the opportunity is there for basically these counties or these municipalities and other political subdivisions to invest in the same manner and in the same vehicles in which the state does. This simply mirrors I believe, the constitutional language that we have for the state of Wyoming. I will double check that. But I think this is pretty much the same language that we have for the state of Wyoming and its investments.
Senator James. I'm having trouble getting your mic on here.
Thank you, Mr. Chairman.
Senator James.
Thank you, Mr. Chairman. So one of the things I find concerning is that these entities have actually enough reserves to gamble on, to actually gamble with here in the market to do this with. And so instead of using the market to do this, why aren't they out there doing the projects, fixing the cities, towns, and other things that actually need to be done with the people's money instead of being out there in the market? And how soon do we start hearing from these entities that they need more revenue from the state, or need to start raising taxes to get revenue to start playing the market? So that's my question. Thank you.
Senator Kinski.
Thank you. I have a question for the Appropriations Chair, and refresh my recollection. I thought that local governments could park money with the state. I think it's in Pool A, but there is a way that local governments can park their money with the state, and the state invests it on their behalf. And I also believe, and correct me if I'm wrong, that Pool A, we've modified that so that some portion of that is not needed in the near future for cash flow needs can be invested more profitably in equities. And if both of those things are true, why can't we resolve it that way? Local governments could just park the money with the state, and the state can invest it currently, and, you know, not all of it needs to go into long-term, just that portion of it that may not be needed for a while. And then to my friend from the southwest corner of the state, the answer is the reason they have reserves is there's a number of them. One, the city might pass the cap tax, and that cap tax is going to be in effect for, let's say, 8 years, and there's a series of road projects that are identified in that. Well, you don't want to begin the road project until the tax has been collected. So you're accruing that money in a reserve account. That's one. Two, prudent financial management of these local entities says that they should have a rainy day fund, just like the legislature does. So there's, you know, various kinds of rules of thumb as to how much they should accumulate, but whether that's 3 months revenue, 6 months, or 12, but you should have some revenue against a downturn. Three, you have reserves just for untoward events. I like to keep a fairly large snow removal reserve. They say if you're going to be tossed out as mayor, the most likely thing is that you prove inept at removing snow in the midst of a big storm. Then the other is your utility funds. You are required by federal law to have a reserve built up to close your current landfill. And you're required to have a reserve to built up to take care of landfills that have been closed as well, I believe. And then you want each of those utility funds, the water system, the sewer system, you want them to have reserves in the event that there's something that comes up, sometimes just operation or maintenance, or it's a capital reserve. And so even a little place like the city of Sheridan, you know, they can end up having $15 to $20 million worth of reserves, 90% of which you can't just go in and grab and spend. It's because it's committed to the 1 cent, it's committed to this water sewer fund, it's committed to the landfill fund, it's committed to snow removal, that sort of thing. And those reserves, depending on circumstance, can be drawn down very rapidly. A big, long snowstorm, you can spend hundreds of thousands of dollars. When the projects finally decide that, when the projects finally are ready to go, you draw down those funds pretty rapidly during a construction season. So there's a lot of volatility in them. They come and they go, but they are necessary for prudent management of any enterprise, and particularly a local government. Thank you, Mr. Chairman.
Senator Scott.
Mr. Chairman, it was earlier mentioned in the debate that these funds would be invested through the state in a state-managed fund. And frankly, that makes a lot of sense to me. But it struck me, if I was reading this and seeing it on the ballot as a private citizen and didn't know that, I would have real reservations about this constitutional amendment on the theory that the local political subdivisions didn't have the sophistication the state has developed, didn't have the sophistication to manage one of these funds, and that would be, and frankly, that the amounts involved weren't large enough to cause development of the sophistication that's really needed. And it wouldn't be a safe thing for a city or county to go do on their own. And this looks like it authorizes them to do just that. My question is, should we specify in here clearly that such monies be invested through the state, and the state would manage the fund? Because I don't see that in the amendment. And I'm afraid that lack of that might cause the amendment to go down in the election.
Senator Perkins.
Mr. Chairman, I've been firstly looking through my Constitution, trying to find those provisions, and I haven't found them yet. But my recollection is that it only allows the state to do that, and it doesn't specifically allow municipalities and these other subdivisions to do that. In fact, the fund in which municipalities, this is answering the former mayor's question. The fund in which municipalities invested had a particular name, and it was invested, and it was limited to fixed income investments. It just simply hasn't done that. We've had discussions with both the current treasurer and the former treasurer over the years about this fact. We've tried to find a way to do it, and ultimately the conclusion is that unless the Constitution is amended to allow this, that it can't be done. And so tomorrow I'll find those and report back and on that specific language. And I agree. And I think you look at the ballot statement and it's confusing. I think we can do a little bit better. It'll be a little bit more specific to show that really all we're doing in this is to do what the counties and a few, it's not a lot of them, but there is a number that have and I think that the former mayor and the good senator from Sheridan eliminated exactly why some of these reserves are there and there for a long time. And ultimately, if you look at that, if you don't do something that allows you to at least cover or potential or receive an increase in value or income that at least keeps you with the cost of inflation, those reserves are being eroded every year. And so if we don't do something to do this, this is what it is. This is, it just increases the risk and increases the burden on the municipalities that do that. And so those are the answers that I have right now, but I'll have more information for you tomorrow. Thank you, Mr. Chairman.
Any other questions? All right, hearing none, call for the question. All those in favor of Senator Nethercott's motion that when the committee of the whole rises to report, that it do so with a favorable recommendation of House Joint Resolution 9, please say aye. Aye. Those opposed, no. House Joint Resolution number 9 has passed the committee of the whole. The next bill for our consideration. Senator Perkins.
Mr. Chairman, it'd be at this hour, I think it'd be really good if we just took a little break, and we'll see if we add another bill or two to the list. And then if we can, we come back in about 10 minutes and finish up for the day.
With no opposition.
I would, at your discretion or a request of you, Mr. Chairman, is that we'd stand at ease for this to the sound of the gavel about 10 minutes.
All right, we'll stand at ease for roughly 10 minutes till you hear the gavel. All right, we're 10 minutes. Committee of the Whole, please come to order. Senator Lanning.
And a quiet settles down over the Senate chamber. Thank you, Mr. Chairman. I just, may I have privilege of the floor? Please?
Yes, you may.
Thank you. As we continue to work these committee of the whole bills, Mr. Chairman, I just wanted to let the Transportation Committee know that we will plan on 5 o'clock. If work is still going on the floor, we will excuse ourselves and gavel in for a Transportation Committee meeting at 5 o'clock. We'll head downstairs to W2. We have 3 bills that will take a little bit of time tonight, Mr. Chairman, so we will leave at 5. Thank you.
Thank you.
Thank you. You're welcome. Thank you.
All right, the next bill for your consideration is House Bill 197. Will the reading clerk please read the bill?
House Bill 197 engrossed Connect Wyoming Program Federal Funding, sponsored by Representative Newsom, an act relating to the energy expenses of government related to broadband internet access. Was referred to Committee Number 2, which returned a committee recommendation that it do pass. Ayes, Senators Guru, Hicks, Kinsky, Perkins, and Steinmetz. Senator Perkins, Chairman.
You've heard the reading of the bill. What's your pleasure? Chairman Perkins.
Mr. Chairman, I move that I'll defer to the Vice President.
Senator Hicks.
Mr. Chairman, I move that when the Committee of the Whole rise and report that you do so with a do pass recommendation on House Bill 197. For an explanation of this bill, I would ask that you call on my colleague from the Bighorn Basin, Senator Cost.
Senator Cost.
Thank you, Mr. Chairman. House Bill 197, Connect Wyoming Program with federal funding. To give you a little background on this, this bill does not create a new broadband program. It simply funds Connect Wyoming program with the current and future federal funds to expand broadband in our state. What this is about is there's a number of our counties that are limited in their broadband ability, and there was a bill with the first Connect Wyoming program, which was with the first funds that was allocated through the federal government to be able to bring broadband into those areas. Some of that is not completed yet, and also there's still a few areas that have not been able to be reached. So this just continues that to allow for those areas where there's limited broadband to be able to hopefully get that corrected. A couple of things of interest. They're saying that Federal Communications Commission established that advanced telecommunications capability requires access to download speeds of at least 25 megabytes per second and upload speeds of at least 3 megabytes per second. I would love to see that even where I am. It's definitely a little challenging for some of our areas. Right now in the state, Bighorn County, Crook County, Goshen County, Niobrara County, Platte counties for sure are all very limited in some of their access, with approximately 116,000 people in Wyoming who have access to only one wired broadband provider. Some of the things we're finding out is some of this fiber runs right through a town, but yet nobody in that town can connect up. And so it becomes rather difficult to understand why. And so this helps to correct that by the funding, as well as some towers in areas where it's extremely difficult to be able to cover everybody. With that, the bill just covers that. It just basically expands to say that if you look on page 2, 1 through 3, lines 1 through 3. CARES Act means the Federal Coronavirus Aid Relief and Economic Security Act, including any amendments to that act. And then on 5 through 10, it talks about Connecting Wyoming, means a program created by the council that used available CARES Act funds for the broadband development projects in Wyoming necessary to respond to the COVID-19 public health emergency by bringing faster and more reliable broadband internet service in unserved and underserved areas. And then council and covered period are there, and you will find it on page 3. There is appropriated to the council an amount determined by the legislature from any unexpended, unobligated funds appropriated 2020 Wyoming Special Session Laws, Chapter 1, Section 2B, and as authorized is made available for expenditure in Section 2C, Romanet II. If CARES Act funds are not available for any portion of this appropriation, the Joint Appropriations Committee or any other committee tasked with developing legislation shall consider appropriate additional COVID-19 relief funds from any subsequent federal COVID-19 relief packages. And that's really all this is about. So rather than spending a lot of time on something that I think everybody kind of understands, I would stand for any questions.
Questions? All right, sensing you're ready for the question. All those in favor of Senator Hicks' motion that when the committee of the whole rises to report, that it do so with a favorable recommendation of House Bill 197. Those in favor say aye. Aye. Opposed, no. House Bill 197 has passed the committee of the whole. Next bill for your consideration is House Bill 197. Will the reading clerk read in the bill, please? I'm sorry. Next bill for your consideration is 179. Will the reading clerk please read in the bill?
House Bill 179 engrossed, optional municipal tax election, sponsored by Representative Zwanitzer. And I beg pardon, an act relating to taxation and revenue was referred to committee number 1, which returned to committee recommendation that it do pass. Aye, Senators Cooper, Cost, and Nethercott. No, Senators French and Colt. Senator Nethercott, Chairman.
Chairman Nethercott.
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report, it do so with the due pass recommendation of House Bill 179, optional municipal tax election. To explain this good little bill, I call on Senator Case.
Senator Case.
Thank you very much, Mr. Chairman. Mr. Chairman, this is a bill that relates to what we passed last year. I used to hate it when people said this when they get and they go, well, for all you new people, remember, I used to always hate that. But anyway, we did have a bill that came about after several years to allow municipalities to have an optional tax up to a penny. They can have a portion much, and it can happen even without the having to go through the entire county. It was a long fought deal. We put it through last year. But there was an amendment that came on by our friends down the hall that restricted that optional municipal tax to only be able to occur on a general election. Now that's a bit problematic, Mr. Chairman. And just let me point out that in current law for bond issue elections, there are 4 times a year or 4 periods when a tax can be put in: a general election, a primary election, and also there's a election in May and an election in August, which of course would be the year when we don't have primary elections. So that's when bond issues can currently occur for municipalities under our existing law. What this bill does is match the periods for having these optional tax elections to that for bond issues. And I'll tell you why we have to do this. It's a little bit more complicated, you think, because the bill about the optional municipal tax says that they first have to have I believe, the 5 cent tax in place. And so and then, Mr. Chairman, to have that first is problematic with respect to the timing, Mr. Chairman. And those elections with respect to the general and the primary, of course, come every 2 years. And so you end up with situations where you would have maybe double taxes at the same time. You might have on a bill or on a proposition on a general election, you could have a possibility that you have the optional municipal tax. You may have the 5 cent tax being up at the same election, or you might have a 6 cent, the special purpose tax. 5 cent is what we call the general purpose tax. The law actually requires, I'm trying to remember, one of the taxes has to be in first before they can even do the optional municipal tax. So it's just a mess in terms of figuring out. What if that tax that has to be in first is up for election at the same time that you have the optional municipal? And then the optional municipal passes, but the other one fails. You have a mess then. Existing law provides a way to handle this, and that is to have the existing bond issue election times. Now, I know that some of you are thinking, well, nobody goes to those optional tax dates, the May and the August dates, and that's just not true. Plenty of bond issues fail around Wyoming on those dates. Happens all the time, and so this tax would not be any different. A mobilized populace, but it fixes the timing issue, Mr. Chairman. Why would we have granted this ability for our municipalities and then have just messed up timing that makes it pretty impossible to implement? I ask for your favorable support. It's a nice white bill. We don't get those very often. You can see that a change was made by our friends down the hall, and where we had eliminated the words general election, thinking that was clear that it meant all elections. The amendment from our good friends was to make it for the same dates as the bond issue election. That's the bill. I'm happy to answer any questions, Mr. Chairman. I thank you very much.
Questions? Senator Cost.
Not a question, but a couple of other things. First of all, the county commissioners need to give them the approval. And second of all, remember, this must be voted on by the county people. So this is an opportunity for the people in the county to be able to make that decision, not somebody else. And I think we've heard that before. It's something people have wanted. This is a good bill for the opportunity for our municipalities and our counties to work together on trying to help where they can get it passed, and where they can't get it passed, it won't count. So I think it's a good bill, and I recommend that we all look at it in a favorable.
Senator Cole.
Thank you, Mr. Chairman. Just, I guess, a point of clarification. I assume that being it was a city taxing issue, would be only relevant to the city that's proposing this tax. Question one. More importantly, though, we're talking about an election that's not in a general election for the question, a taxing question. And I think the folks in the districts or the areas where this question might come up in that municipality deserve to have it be on the general ballot, not in some special election. I agree with the good senator that introduced the bill that it is a mess, and I agree to that. It is a big mess because of some conflicts that exist as were explained. But we sit here asking I sit here and represent the folks that are the ones that believe a general election is the right time, because more folks turn out for that election. And that, in fact, was testified by one of the people in committee that there's more of a turnout. I think we're all facing taxation issues, many places. And frankly, it's probably the first one to get on the ballot has a higher likelihood of getting that said tax. And because of that, I think these issues should be on a general ballot. We can allow the constituents to pick which tax they want, be it a city, special purpose tax, whatever be the case. But I would like to know the answer about the cities, in fact, having their own ability to set tax rates to increase by the penny. Thank you.
Senator Case. Oh, you, oops. Senator Hicks.
Yeah, Mr. Chairman, just a real quick question on this. So this is already, we're just moving the dates around, but I'm curious as to how many optional taxes now could potentially be on the ballot, because we've done some stuff with the lodging taxes and then the fifth penny taxes and then the bonding issue. So how many actual mills can be generated by a municipality if they wanted to impose all of these? I don't have the question, just if somebody knows the answer.
Senator Case.
Thank you very much, Mr. Chairman. So, Mr. Chairman, this is about sales tax. It's not about property tax. So we're not talking about mills here. Municipalities are limited to 8 mills via the Constitution. They can have bond issue elections for different things to have bonds that they pay off. Those bond issue elections can occur in these 4 periods. The general election, the primary election, and then also an August election, and in the off year from the other elections, an August election. It's like the first Tuesday after the first Monday, I think, those off elections. So we are dealing with municipal taxes. There could be things like the lodging tax, which would be a countywide thing, but yes, there could be a county deal. There could be the 5th cent could be up on the same election, which is the general purpose 1 cent, up to 1 cent tax. There could be the 6th cent, which we commonly refer to as the special purpose 1 cent tax. That's a little bit of a truncated explanation of it, but those all could be on at the same time. Our law about the optional municipal tax, and this is just municipalities, has nothing, I mean, it's connected to the counties, and what we're doing here is allowing them to do this without going through the counties and having all the governments agree and being countywide. So that was the bill that we passed last year after many years of effort. But certainly you could have several taxes on at the same time. And restricting this to the general election is particularly troublesome, because you can imagine you could either have that general purpose tax on at the same time where it's being approved, or the special purpose tax, which is required to do the optional tax on the same ballot. And I'm trying to figure out what would happen if one passed and the other didn't. So, my experience with people on bond issues, if you put a bond issue out there, it's not a sure thing. So people know about these, the May and the August elections. They mobilize very well. Who is the most mobilized, the forers or the againers? I can't begin to tell you that. But I would say that in a targeted election, it's pretty easy for people to get their word out to defeat the tax, because you're not suffering from all the noise of all the rest of the election stuff. So I'm not ready to say that it favors passage of the tax or not favors passage of the tax, but it does make it workable in the timing. I hope you support the bill.
Question. Hearing the question, all those in favor of Senator Nethercott's motion that when the committee of the whole rises to report, that it do so with a favorable recommendation of House Bill 179. Those in favor say aye. Aye. Those opposed, no. No. Division's called. So those in favor, please stand. Is he? You vote? Oh, okay, all right. Thank you. Pardon? Okay. Those opposed, please stand. Oh, okay. French, no. Okay, you may be seated. The ayes are 14 and the noes are 13. So House Bill 179 has passed committee of the whole. The next bill for your consideration is House Bill 195. Will the reading clerk please read the bill?
House Bill 195 engrossed, Wyoming Medical Review Panel repeal, sponsored by Representative Olson, an act relating to the Medical Review Panel. It was submitted, referred to committee number 2, which returned to committee recommendation that it do pass. Ayes, Senators Guru, Hicks, Kinsky, Perkins, and Steinmetz. Senator Perkins, chairman.
You've heard the reading of the bill. What's your pleasure? Chairman Perkins.
Thank you, Mr. Chairman. I move that when the committee of the whole rise to report, they do so with a recommendation that House Bill 195 do pass. And for an explanation of the bill, I ask that you would call upon the Senator Nethercott from the Laramie County area.
Senator Nethercott.
Thank you, Mr. Chairman. Good senators, what this bill does is save the state some money and reduce inefficiencies in a system that was intended to create efficiencies, but in reality is probably not working as intended. And so in 2005, the legislature created the medical review panel in order to review medical malpractice claims and kind of provide an administrative process before the ability to take formal legal action against a medical provider. In reality, this process has been found to be burdensome and rarely used, primarily because those actions are rarely done, believe it or not. And so with that, I'd stand for questions from this very interested body.
Questions? Sounds like you're ready for the question. All those in favor of Senator Perkins' motion that when the and the committee of the whole rises to report that it do so with a favorable recommendation of House Bill 195, please say aye. Aye. Those opposed, no. House Bill 195 has passed committee of the whole. Senator Perkins.
Thank you, Mr. Chairman. I move that the committee of the whole rise and report. I don't have anything to do. We're just about the list is. Ogden told
You've
me
heard
not
the
to put a
motion.
bunch
All in
of
favor,
them.
say aye. Those opposed, no. Mr. President, I move the adoption of the committee of the whole report.
Not yet.
Not yet.
Just let you know it's coming. Oh.
Reading clerk, read the committee of the whole report.
Mr. President, your committee of the whole, having had under considerations bills on general file, begs leave to report as follows. House Bill 229 engrossed, do pass amended. House Bill 207 engrossed, do pass amended. House Bill 43 do pass. House Bill 17 engrossed, do pass amended. House Bill 41 engrossed, do pass. House Joint Resolution 9 engrossed, do pass. House Bill 197 engrossed, do pass. House Bill 179 engrossed, do pass. House Bill 195 engrossed, do pass. Senator French, Chairman.
Senator French, go ahead.
Mr. President, I move for the.
We'll have you stand if you could, please. Thank you. Thank you.
Mr. President, I move for the adoption of the Committee of the Whole report.
Heard the motion? All in favor, say aye. Aye. All opposed, nay. Motion passes. Thank you, Senator French. Good job.
Mr. President?
Go ahead. President.
Thank you. Mr. President, I'm assuming the chief clerk just told you about the little situation that we have with respect to, have we heard back on what the House has done with the, Mr. President, what we, I think you, if I may have privilege of the floor.
Please do, and I
And let-
understand we are waiting for something to time to catch up with from the other side.
Right. So what, long story short, what the House, since it's a House Bill 1, we can't sign the enrolled act. We'd like to get the budget to the governor today to start the 3 days on the budget. They passed it up, so we can do it now? Oh, in that case,
That's the word I'm
never
getting
mind,
here.
Mr. President.
All right, so I guess we're good to go from that. Yeah, very good.
Well, do you have, Mr. President,
Please,
do you have HB 1 in front of you yet?
I'm looking. I'm just getting handed material here, so.
Okay, so
No.
if, Mr. President, if I can rehab privilege of the floor for just a
Please.
moment to explain what's going on. So what we've got is the, apparently the other side has now concurred on, or at least voted up the Joint Conference Committee on HB 1. However, it's that enrolled act for it to get to the governor has to be signed, of course, by the heads, by both the speaker and by you, Mr. President.
Correct.
And so it's got to be signed down there first and then come down here. And so we can't adjourn until that happens. Staff is all over that. They're going to get it here as fast as they can.
And that's my.
But ultimately, we can't really adjourn until that point in time. But Mr. President, and you've got a few things to do, but we would like to, I believe, how many committees do we have that meet on adjournment tonight?
Who's up tonight? One.
Just transportation?
Transportation,
And-
Senator Landon.
And
You
we
can
would
delay
like,
someone?
we would like to, what do we have? We have a referral. So what we'd like to do is we've got to have a majority on the floor. We've got a quorum for the president to take his acts. We'd like to go ahead. I know they've got a heavy schedule in Transportation Committee with your, by your leave, my liege, or by, Mr.
Are we
President.
leading up to
We'd
excusing
like to
them?
excuse the Transportation Committee go and take up their work if we could, so they can get started on their adjournment, or their work on adjournment.
Senator Landon, would you like to leave?
That'd be awesome.
Okay. All right, transportation is good to go.
And then I think that if that takes 5, I think if appropriations goes, we have one a brief referral. I think we can also go and do our thing while we're waiting and still have a quorum. I think we can do that as well.
Senator Case.
Mr. President, in order to make it work, we could retrieve you to come back to the floor as well. So we just stand around at the sound of the gavel and we can go get you.
There's come and get us, we'll be back. I don't think, this is a referral, so I don't think we'll be gone more than 10 or 15 minutes as it is. As
Take
far
care
as
of your
appropriations.
referral. All right. Senator Landon, you want to follow up?
Mr. President, I was just going to offer, if you need numbers, I could get a hold of Senator Furphy and he could run upstairs. He could run all the way up here and
Senator Furphy, you're the designated runner.
so you just let me know, Mr.
Okay,
President.
all right, we're sending transportation off to do good things.
And Mr. President,
Please.
the Senate Appropriations will also be meeting in 5 minutes in the in committee room 301 above to take up a referral of Senate File 188, which is it's just to look at some loan provisions on the Senate File 188 is, excuse me, House Bill 188, which is irrigation district loans.
Okay. All right, so what we'll do, I guess, can we stand at recess and let the two committees go?
Stand at east to the sound of the gavel. Mr.
Yeah,
President.
and the two committees will go do their work. All right, good enough. Stand at ease until the sound of the gavel. And we'll wait to finish up things later tonight. Thank you. Those of you in the chamber still, those of you in the chamber, we're looking at approximately a half hour to 45 minutes, okay? All right, thank you. Let me double check with our sergeant at arms. Are we good? We're good. We're at that order of business signing enrolled acts. I didn't think you folks liked enrolled acts. Okay. House Enrolled Act 45.
House Enrolled Act number 45, being original House Bill 1, an act relating to supplemental appropriations and reduction of existing appropriations for the operation of state government for the fiscal biennium commencing July 1, 2020, and ending June 30, 2022.
I'm about to sign House Enrolled Act number 45, the same being original House Bill 1. I have so signed. Let's just take care of a few others while we're at it here, folks. House Enrolled Act 18.
Senate Enrolled Act number 18, being original Senate File 119, an act relating to public funds.
Excuse me, let's, for the record, Senate Enrolled Act 18. About to sign Senate Enrolled Act 18, the same being Senate File 119. So signed. Senate Enrolled Act 19.
Senate Enrolled Act number 19, being original Senate File 93, an act relating to the Western Interstate Commission for Higher Education, WICHE, repayment program.
About to sign Senate Enrolled Act 19, same being Senate File 93. So signed. Senate Enrolled Act number 20.
Senate Enrolled Act number 20, being original Senate File number 79, an act relating to school finance.
About to sign Senate Enrolled Act 20, the same being Senate File 79. So signed. Senate Enrolled Act 21.
Senate Enrolled Act number 21, being original Senate File 72, an act relating to administration of government.
I'm about to sign Senate Enrolled Act 21, the same being Senate File 72. So signed. Senate Enrolled Act 22.
Senate Enrolled Act number 22, being original Senate File 62, an act relating to the Office of the Consumer Advocate.
I'm about to sign Senate Enrolled Act 22, the same being Senate File 62. So signed. Senate Enrolled Act 23.
Senate Enrolled Act number 23, being original Senate File 40, an act relating to trade and commerce.
About to sign Senate Enrolled Act 23, the same being Senate File 40. So signed. Senate Enrolled Act 24.
Senate Enrolled Act number 24, being original Senate File 39, an act relating to trade and commerce.
About to sign Senate Enrolled Act 24, the same being Senate File 39. So signed. Mr. Vice President, we need a motion to adjourn. I'm running out of leadership here. Mr. Vice President, speaking of being out of leadership, I need you back in here, my friend. Give us a motion to adjourn.
I move that the Senate adjourn until 10 PM.
Wait.
What's that?
10 a.m., sir.
10 AM. No, I like 10 PM.
Tonight?
10 AM on Tuesday, March 30th.
Very good, thank you. Announcements, Senator Ellis.
Thank you, Mr. President. The Travel, Recreation, Wildlife, and Cultural Resources Committee will meet tomorrow at 12:30 in Capitol Extension Room E05 and online to discuss interim topics. And just wanted to make you aware and remind you that tomorrow night is taco party for anyone interested. Should be fun.
Those are good. Okay, Senator Nethercott.
Thank you, Mr. President. Tomorrow morning, your lucky number 7 committee corporations will meet at 8 a.m. to hear the following 4 bills. House Bill 156, alcoholic beverage permits. House Bill 163, federal congressional elections residency. House Bill 75, voter identification. And House Bill 187, elected official residency requirements. Your lucky committee number 7 will also meet upon adjournment to hear the following 2 bills. House Bill 158, local land use planning and zoning, and House Bill 96, treatment of animals.
Thank you, Senator, covering all that. Senator Cost.
Thank you, Mr. President. Agriculture will meet upon adjournment tomorrow, Tuesday, March 30th, in room West 2, and we will be covering House Bill 51 in gross meat processing programs.
Thank you, Senator. Senator Kinsky.
Thank you, Mr. Chairman. Appropriations Committee number 2 will be meeting noon tomorrow or a few minutes after recess in Joint Appropriations Committee Room 301 to discuss interim topics. And then, Mr. President, just a point of order for
Please.
conference committees, are we supposed to announce those in advance or no?
Yes, go ahead if you've got time.
Okay,
Please go ahead.
so tomorrow, HB 49, the conference committee on HB 49.
Could you state the name of the bill?
It's HB 49 agency fee revisions.
Thank
We'll
you.
be meeting with our House counterparts in HB 113 at 1 p.m.
Thank you, Senator. Further announcements? Further announcements? Senator Steinmetz.
Thank you, Mr. President. Your joint conference committee on House Bill 73 will be meeting in room 110 on adjournment tomorrow.
Thank you. Further announcements? Thank you, folks, for your patience today. It's good to get that bill taken care of, HB1. You've heard the motion. All those in favor say aye. Those opposed, nay. Senate will stand adjourned until 10 a.m. Tuesday, March 30th. March 30th.